Namaste ji, namaste. Welcome to Law of Crimes under the UPSC Law Optional. Now, first and foremost, when we have to study law of crimes, we need to define what a crime is. But then that is a very dry philosophical subject, so I don't want to start off from there. I'll keep on introducing those concepts alongside whenever we're discussing the sections, all right? So let's start off with the interesting bit. And now let us hear a voice before we start off with this. I swear to God, if this person asks one more question to the teacher and doesn't let him take attendance, I am going to smash his head. These are your thoughts, right? Some point of life, you must have said that I am going to kill this guy. If he asks me, or if he asks the professor one more question, right at the time of attendance, the front benches start and the back benches are like, oh my God, correct? With that, let's come to mens rea and actus reus. So, if you have ever taken a LLB entrance before, if you have ever studied law before, these are the two fundamental MCQs that come, that mens rea means guilty mind, actus reus means the act. But when we are specifically talking about the UPSC law optional, remember we're not tackling MCQs here. वो तो आपका prelims का काम, it's a separate story altogether. We have to write some amount of language, and that language is crucial. So we're going to start off with the fundamental principle of criminal liability is, or the fundamental principle of criminal liability contains two crucial elements, that is mens rea and actus reus. Alright. So mens rea is basically, when we come to the etymology of the word from Latin, mens means mind, plan, intention, and rea is not rea from the Sushant case. Rea means guilty or liable. So a guilty mind. You have a guilt in your mind and you combine it with an act, therefore it becomes a crime as per the applicable law. Alright. So for example, in the voice note, the thought rather, that we heard earlier, you never committed the act, it was only a thought. We cannot prosecute you for thoughts, because if we were prosecuting people for their thoughts, every one of us would be in jail in one instant, right? And why can't we prosecute you for your thoughts? Because we'll say that you are thinking this, and your defense will be, how do you know? Are you a mind reader? How do you know? So how do we know? If you couple it with an act, so we have something to show for your thought, that this was your thought and the intention was developed. You took an act which caused a wrongful loss to the other guy, and therefore now we'll prosecute you. Alright. So mens rea, again, let us consider another example. For example, let us say that you are in the market, you're going down the market, and somebody just bumps into you. Let's say that you're roaming around your college campus, somebody just bumps into you, stomps your foot accidentally, and then the first thing that they say, if you know Hindi that is, and I'm trying to keep this course primarily in English because we have people from all regions and languages, and primarily we write answers in English only, कि मैंने जानबूझ के नहीं किया, right? That I didn't intentionally do it, it was merely an accident. Therefore, since this element is missing, even though the act is there, it's not pretty much a crime. Now, if you want to claim damages, then that's a story of torts, by the way, right? So we'll stick to crime in criminal law. And criminal law, what is the primary objective? That we want to punish the other person. So when we talk about defamation under the IPC, primary objective is we want to get this guy to jail. And under tort, when we sue for defamation under a civil suit, then what do? We want that guy to pay us damages, all right? That is money, basically. Now coming back to this example in which the other guy has now stomped your foot. But let us say that you have personal enmity against that guy. For example, let's take the example of Kabir Singh, right? Kabir Singh had that sort of an enemy roaming around in campus only, who was forever after his life, because he had developed a lot of enemies after doing a lot of fights. If you haven't watched Kabir Singh was a rowdy, sort of an aggressive character who picked up a lot of fights in the movie, that is. So therefore now when that sort of an enemy or that sort of known person comes and stops, let's say, Kabir Singh's foot, we can say that he did it janbhooj ke, or intentionally he did it. Now, obviously, that's a separate story altogether, that Kabir Singh is going to punch him and won't ever get him prosecuted. But for our understanding, janbooch ke element, that we want to hurt this guy because he's our enemy. And what is the act? The act is actually that you've gone and stomped on his foot. All right. So that is the act. And mind you, it has to be, the key word is wrongful. So the intention also has to be wrongful. Now, what does this mean? For example, let us say that you are a surgeon and you tell your patient, again, let us say that you're Kabir Singh, presume that you're Kabir Singh, again, he was also a surgeon in the movie. And presume that you tell your patient, well, let's say Mr. Mehra, that if you don't get this surgery done in the next 3 days, pretty much you'll die. And let us say that Mr. Mehra dies. And you're like, bloody hell, I didn't intend it. Where was the mens rea? What was the intention? Intention was to actually get yourself to save the patient, right? And what was the act? That you told him. But then the other person were like, he dies. Do we prosecute you under the IPC? Homework number 1. Pick up the Bare Act, and this course won't work without the Bare Act. So pick up the Bare Act and read section 93. Communication made in good faith. Now remember, our intention is to save the guy. And the act that we have done is we have told them this. But jab intention hi nahi hai to murder the other guy, or rather to kill him, how exactly is the law going to prosecute us, right? So therefore, 93, that is the first homework. Now, since you're picking up the Bare Act and reading sections, read another section, that is section 82. Now you'll say, don't I have to read 1 to 82? We'll get to all of that, don't worry. First read 82. 82 says, nothing is an offense if done by a child less than 7 years. That's not the exact language of the section because I don't have the Bare Act with me. But 82 is basically the concept of doli incapax, that is, the child is incapable when he or she is less than 7 years. That is what our lawmakers presume, that they are incapable to develop an intention or mens rea. That is, koi kaam unhone janbooch ke nahi kiya, because that time the child is very, very young, right? So in exceptional circumstances, the child can know what he or she is exactly up to, but that can be argued in a court, and that's a separate story. But generally speaking, why does this section exempt children who are under the age of 7 years and allows them to do anything which and won't be termed as an offense by the IPC? Why? Because it says mens rea wo develop hi nahi kar sakta. So it's not the janbooch ke hai hi nahi. Let us say an animal accidentally bites you, a dog bites you. Why do we let go ki nahi jaane do? Or let us say a lunatic, you know that the person is of an unsound mind. You always let them go. Nahi. Let us say that they hit you. What exactly is happening there? Because we presume that even though they have committed an act, there is no intention behind it. All right? And in your answers, you must give at least 2 examples of these 2 concepts so that the examiner knows that we have understood. And primarily simple examples in simple language, no fancy Latin needed, no fancy flowery language needed. All right, keep it simple. If we stick to the basics, we'll be able to secure more marks. Now, based on this, so this is the mental aspect of a crime, this is the physical aspect of the crime. Both, when combined, are pretty much a crime, right? And that is what we'll prosecute you for under the IPC. Where is the procedure given? That's in the CRPC. So IPC defines the offenses. CRPC tells us what kind of an offense it is, as in whether it's a bailable, non-bailable, compoundable, non-compoundable, and the third type of classification is cognizable and non-cognizable, but it is all procedural. So what is a murder, what is rape, what is kidnapping, what is abduction is IPC. What does the police do, what does the magistrate do, how is the FIR to be recorded, where is it to be forwarded, what is the procedure for arrest. See, all procedure goes to the CRPC. So that is a procedural law, and this is what we are calling as a substantive law. All right. And this is where chapter 4 general exceptions 76 to 106 is there, where the intention is missing. So an act has been committed and it's leading to a wrongful loss to the other, but since the intention was missing, it is a general exception out of the crime. You are going to make a cursory look on these sections. No need to remember the sections, no need to, right now at this stage, no need to remember the language of the section, no need to remember the section numbers. Just go through them once. I believe it will be of help to you. Okay. And then there is private defenses as well, section 96. So whenever we're writing the answer, if we are able to connect mens rea to chapter 4 general exceptions, and Actus, I'm going to give you one example. But let us first and foremost now discuss private defense. What exactly is private defense is, for example, let us say a lunatic is coming at you with an axe, and you know if you don't kill this guy, he's going to basically, just like God of War or something, just take off your head, right? Or even in Avengers, right? Take off Thanos' head by, I think Thor did it, yeah. Thor has an axe. So now what is your intention? Your intention is to save yourself, right? So therefore you commit an act in which the other guy gets killed. That is completely fine. That is completely fine by the IPC, because your intention is to save yourself. Your intention is not to kill the other guy. And mind you, there is a difference between intention and motive. We'll have to get to that as well. Okay. Now, there are some offenses in the IPC which do not require a mens rea at all. So they are called as strict liability offenses. We don't care for your intention. As soon as you've done them, that's it. You are inside of the domain of the IPC. We can prosecute you. Okay. So for example, section 292, obscene material. As soon as you're selling, let us say, pornographic books or anything which is obscene, which goes against, let us say, the constitution की language use करते हैं, public order, health and morality, you're pretty much done for under 292. Your intention or your defense will be, look, I'm trying to earn a living here. This is all that I know how to do, is to sell pornographic CDs. Well, that's a very shady statement to make. But they don't care about your intention here. As soon as you've done this, you're gone. So we'll be discussing more strict liability offenses in detail. This is one example. I believe if you quote this example, whenever you are talking about actus and mens rea, that is, not mens, I believe you will make pretty much a good answer, all right, for the purposes of law optional. Remember, so we have to factor in the exam that we are writing for and therefore only take up the answers. Now, I would take a different route, like for example, if I were writing a judiciary ka mains ka answer. But this pretty much would be on a similar track, but I would have to enter into a couple more details. All right. Such result of human conduct as the law seeks to prevent is the I would say the formal definition of Actus Reus. I believe this is pretty much self-explanatory, and these two combined are the you can say the crucial elements, constituent ingredients of crime. Okay. Now, for example, another thing that you will mention in your answers with Act is section 32 and 33. The word act extends to an omission as well. So let us say that you don't like your wife. I mean, not many do, but then let us say that you don't like your wife and you stop giving her food. Let's say that you lock her up in a room and you stop giving her food and eventually she dies off. So was it an act of murder? Yes. Intention to kill her. Actus. Now you'll say, but I didn't commit an act. But you did omit something, right? Where is omit? Yeah, omit. अच्छा, omit की spelling double M नहीं use करेंगे. O-M-I-S-S-I-O-N. Be careful. If the examiner spots this, आधा नंबर उड़ा देगा, एक नंबर भी उड़ा सकता है, depending on whatever the mood he or she is in. So don't make these silly mistakes, especially when you're writing answers in English. All right. So act extends to illegal omissions as well, in which legally you were bound to do an act, but you said that I'm not going to. So that is an omission. And let us say, whenever we're talking about Actus Reus, is it one act? No. Section 33 tells us it is a series of acts. And the series of acts, then we'll have to consider chapter 5, abetment and whatnot. but quote section 32 and 33 whenever we are talking about Actus. All right. And here for mens rea, pretty much you can use general exceptions without even going into the specific details, and pretty much the examiner knows that now the funda of these two concepts is pretty much clear in this guy's head. And that is what our aim in a competitive exam is primarily. Now, voluntarily. So IPC में जब भी आप mens rea वगैरह सब कुछ देखेंगे, you want to notice these words in the section: intently, willfully, voluntarily, knowingly, dishonestly, fraudulently, right to believe. What is all of that? That is a demonstration that the section is focusing on intention. So you have voluntarily done this, you have intentionally done this, you have willfully done this. Now voluntarily in section 39 you're going to read up the illustration, and the illustration goes something to this effect. Like for example, you are committing robbery, and to commit that robbery you set a house on fire and somebody dies. Then you're going to tell me that, look, I didn't have any intention to kill that guy. I'm sorry, I didn't have any intention. But then you voluntarily did it. You voluntarily caused the person's death because you know, you have the knowledge that if you set a house on fire, somebody or anyone who's inside, the likelihood of that person dying is very high. So you've voluntarily done this. So therefore, we're going to catch hold of you for death as well. You understand? So 39 becomes important, but 39 you can't really quote in an answer. Good to understand how exactly do we get to your mens rea and actus reus. Just good for conceptual clarity. I'll tell you in the further videos of where to use voluntarily and where to write section 39. Another homework, you're going to pick up the Bare Act, you're going to read illustration of section 39. And mind you, without the Bare Act, without you doing work on your own, you can pay 1 crore of rupees to any person, any coaching, whatever it is, and it won't make 1% difference to your prep. Okay. So the Act, also now remember we're discussing the Act. So these are all features of the Act itself. Now the Act has to be prohibited by law. So for example, let us say that again, Kabir Singh tries to kill off someone, his enemy, right? And he shoots him. But then instead of killing off the enemy, he has killed a rabbit. Enemy bach gaya, samne wala just ducked, maybe Preeti saved him or whatever it is. And then the rabbit was killed. Can we prosecute Kabir Singh for now crucial word, for killing of the rabbit? No. Is hunting an offense under the IPC? No. But can we prosecute Kabir Singh, generally speaking, for an attempt to commit murder? Yes. Why? Mens rea, Kabir Singh wanted to kill off his enemy. Actus pointed the gun at him, shot it. As simple as that. Attempt में चले जाएंगे ना? So 307. But for the rabbit, we can't prosecute him because that act is not prohibited by law. भैया मार लो, कोई problem नहीं है, right? So therefore, in that case also, what will be the defense of Kabir Singh be trying to prove that we didn't have any mens rea, we didn't have any intention to kill off the other guy? The prosecution will be like, look buddy, he's an old enemy of yours, you had a gun, you had it pointed at him and then you took a shot. This is how pretty much criminal cases work. So criminal cases पूरे के पूरे घूम फिर के, all of it comes down to, when we're not talking about procedural laws here, comes down to mens rea and actus reus. Okay. Now is preparation a crime? In one case under 399, homework for you, you're going to read 399. When you're preparing for a dacoity, then it's a crime. But let us say that you forge your mark sheets for admission to any prestigious university, let's say Delhi University or NLU, wherever it is. You do all the preparation inside of your home, but then you never send it aage. You never send it to the university for admission. So will that be counting as preparation and attempt? Just trying to arouse some curiosity inside of you. We'll discuss this when we come to section 511, attempt. But just mere preparation of a crime on which you'd never committed an act, remember? Thodi si aapne preparation hi kari thi. Now preparation, many lawyers can argue that, you know, that it's under an act as well because now you're preparing for it. So unless and until, somebody just comes to your house, or those authorities against whom that you're trying to commit the crime, they come into your house and grab hold of it, then obviously we have some act to prove it against you. But then that example again becomes very complicated with multiple amount of stories. Let's not get there. We'll discuss it when section 511 attempt comes. But preparation to commit dacoity is explicitly given under 399 IPC. Okay. So therefore now we come to, we've discussed the etymology. The basis is the meaning of the maxim, and I'm not quoting the maxim right now. Maxim baad mein karenge, because otherwise people try to rote learn the maxims and are only focused there. The act does not make one guilty unless the mind is also guilty. That is what the act is non-facet baad mein. The act does not make one guilty unless the mind is also guilty. So for example, Navjot Singh Sidhu example. You get off your car and then you basically hit the other person in road rage and then the person dies. So are you guilty of murder or are you guilty of culpable homicide? Because the person has died, right? What did I say? The act does not make one guilty unless the mind is also guilty. Surgeon, example, you just told the other person ki bhai sahab aap to gaye, and then the person actually just hears this and instantly goes like, oh bloody hell, we are dead now, right? But will it be murder? No, right? So the act does not make one guilty unless the mind is also guilty. मैंने जानबूझ के नहीं किया. That is what mens rea is. Okay. So this is pretty much the sine qua non. If you use now, you can use this phrase because that is pretty much, pretty much we can say that is the essential element that is needed for a crime. Okay. This I've already discussed. Now what is intention? What is motive? This usually is mistaken to be a similar thing. So whenever you're talking about mens rea, if you can discuss intention and motive, let us say it's a 15 marker or it's a 10 marker, it's basically a lengthy answer is required to be written, and then mens rea के अंदर आप intention और motive समझा देंगे, I believe you will fetch some very good marks. Okay. Now motive, for example, let us say that I pick this is a sharp object, it has a screw on top of it, and then I hit you. What is my intention? Intention by picking this and hitting you is basically to inflict damage onto you or to kill you. And I don't want to do that, this is just an example, right? So the intention is this, right? So intention to put in damage to you. But then what is my motive to do this? Motive is something that precedes intention. So for example, let us say that there is one, now I'm not going to use the you in this example, it becomes very funny. But let us say that, that Ramlal ji has a crush on someone and Shamlal is dating that girl. Okay. Now Ramlal is very jealous that he thinks in his mind that if Shamlal is eliminated out of the equation, that girl will automatically come to him, right? Because otherwise Ramlal would be a kanda or a shoulder or must have been friend zoned or something like that. Now Ramlal, let us say, murders Shamlal, right? And using a knife. Presume that this is a knife. Now when Ramlal is coming at him with a knife, his intention is to murder him. But what was the motive? Motive was jealousy because he wanted to be with the woman that was with Shamlal, right? So Ramlal and Shamlal, very old names I've used. Used some modern ones, but then people get offended. Anyway, so what was the motive of the crime? Motive of the crime was to get the woman here, right? Or motive, we can say it was jealousy. But intention kya thi? Intention of the act, picking up the knife and actually inflicting damage onto the other person is murder, right? So that is primarily the difference. Now when we use this example, but obviously we'll have to elaborate it a bit and use it in a language which the examiner understands. So motive is which leads or tempts the mind to indulge in the crime. Okay. So usually prosecutors also are unable to find the motive, but if you are able to find evidence of the motive, you will actually reveal the intention. So if the evidence, let us say the motive in a case of recovery of money is, okay, consider this, that you are a lender, you are a money lender, and somebody has taken a hell lot of money from you and is now absconding. So you hire a couple of goons, you tell them that you find that guy, you threaten him, doesn't give the money, uda do usko. Okay. So evidence of motive, you can say, what was your motive? Motive was to recover the money, first and foremost, right? And then the act is that you hired the couple of goons and instructed them to go and do something, either murder or either recover the money. But what was the motive of the crime? To recover the money. And then let us say that he doesn't give you the money, then the intention becomes, well, the intention of the goons then become, and then you will be under abetment and things get a little more complicated, reserved for further discussions on the topics. But then what is the intention? Let us say that then the goon picks up a club and then tries to hit the other person. What does that mean? The intention is then to kill the other guy. But what was the motive? Recover the money. All right. So motive is what impels a person to act. It's either envy, fear, jealousy, or stuff such as that. So it is I would say that it sits on top of intention, and usually motive is not really focused on because time kiske paas hai. But usually the police in its criminal investigations, whenever they're gathering evidence, they try to find the motive, and then intention automatically reveals itself. तो इसीलिए जब पुलिस वाले, if you've seen Crime Patrol, they always ask कि आपकी किसी से कोई दुश्मनाई थोड़ी तो नहीं है whenever starting the investigation. What does that mean? They're trying to find the motive of the crime, because if the motive is found, pretty much the intention, because the intention will be revealed in the act itself, but the motive is a precursor to that. All right. So whenever we're talking about negligence and knowledge we've discussed a bit about voluntarily in the voluntarily bit under section 39. Voluntarily is basically, again, knowledge is you pretty much knew that this act is going to cause you the death. Now, what does negligence mean? Negligence is under 299, 300 primarily. Now, let us say that thanks to your it's under a couple more sections, but negligence primarily is that when thanks to your rash and negligent act, somebody else dies. So you will say, nahi, meri to koi intention nahi. Let's say that you drink and drive, and then you go over the footpath, and let's say that you are a famous actor, and then the driver and nobody was driving the car eventually. But under your negligence, thanks to your rash and negligent act, somebody's died now. So that becomes a crime, right? But then what was your intention? Was your intention to kill someone? No, your intention wasn't. But then that means that we don't prosecute you for the crime that you have just committed? Well, we do. So basically you owe a duty to your fellow human beings, so that no wrongful loss, or thanks to your wrongful act, is committed onto them, and therefore they do not end up losing their life, limb, or any damage comes to them. Okay. Now vicarious liability is given 154 and 155 of the IPC. That will come to later. Vicarious liability is usually a concept of torts, but it's given in the IPC as well. Just introducing the concept to you, homework for you, 154 and 155. So hopefully now, everything that we're going to discuss in the law of crimes will boil down to mens rea and actus reus, by the way. Everything will come down to it, and I'll keep referring to it again and again and again. We'll be breaking down all the important topics in your syllabus as in sections, because I work with the Bare Acts. So if you haven't bought the Bare Act, or haven't bought, if you're using a digital device, you can download it. It's attached in the course itself. Otherwise, usually it's a good idea, because it's very exhaustive. It's a very long discussion that we're going to have based on the sections. It's a good idea to buy the Bare Act, because you'll need to do a lot of underlining, a lot of sticky notes to put in there. And that's pretty much it for today. Now let's meet you in the next one. We are going to start off with the general exceptions. straight. I'm going to jump into general exceptions, because if general exceptions are clear, by the way, most of the IPC is clear. And as a future public servant, we need to focus on offenses against the state. And what you must all, as a know, for example, as a future DM, a district magistrate, right? What all you must know, the sections of the IPC that you must know, because you are an interface between the government and the public, right? So you are pretty much here. So we'll have to discuss those sections as well. Those sections are usually overlooked for the purposes of any law entrance or higher level law examinations. But in your case, since we're talking about the UPSC Law Optional, we'll need to enter into those sections and connect it with the CRPC as well. And then basically I'm going to cover out all the essential aspects. Now, remember, just because you have fever and you take 1 crocin doesn't mean that you take 10 crocins and the fever is going to completely vanish off. So whenever you're preparing for, especially for this optional, remember we need to keep our knowledge also limited in a very focused sort of a manner, because otherwise law is endless and we need to manage the time for answer writing. So we'll be discussing pretty much all the previous years, talking about future model answers, the questions that they can ask, and it's going to take me a lot of time to prepare this. It's going to take, it's a 4 to 6 month long course. All right, take very good care of yourself. Let's now meet you in the next one. Take care, bye.